Hello, everyone. Welcome to the Module 5 live session for the Contracts course. This week, our topic is Contracts in the Electronic Age. Your assignments for this week are to first read chapters 4, 9, and 13 in the textbook, and then you'll be preparing a written assignment about cheating the elderly. You'll need to watch this live session video. And just a reminder, spring term 1 ends on Tuesday. It's hard to believe that we are in the last week of the course. It's a 5.5-week course, and module 6 is only going to last for 2 days, Monday and Tuesday, and then spring term 1 will end on Tuesday. So I need for all of you to submit your assignments by Tuesday at midnight Central Standard Time. So let's talk about contracts in the electronic age. Research requirements to form a contract remotely. We're going to talk about using computers and other electronic devices to form a contract. We're going to learn how to choose clear and effective clauses to exclude warranties. We're going to review the concept of illegality, research incapacity and undue influence, assess fraudulent contracts, and then judge the ethics of working with incapacitated persons. Let's start talking about unenforceable agreements. We've talked about valid contracts having offer, acceptance, consideration, clear and definite terms that are accepted with definite subject matter and consideration. Let's talk about when an agreement can't be enforced. We know that an agreement cannot be enforced if it doesn't satisfy the statute of frauds. That only applies to contracts for marriage, contracts that can't be performed in a year. The statute of frauds applies to contracts for the sale of land or for the sale of goods greater than $750 under the current version of the UCC. Under the old version, it was contracts greater than the sale of $500. Guarantor and co-signer agreements, those also have to be in writing. If an agreement that must be in writing and signed by the party who's going to be charged is not, if that contract's not in writing and not signed, it is unenforceable in a court of law. There are other types of unenforceable agreements as well. One would be a contract that is entered into by somebody who is not of the age of majority. Contracts entered into by minors might be unenforceable under the infancy doctrine. Contracts that are entered into by someone who lacks the mental capacity to form an intent to contract may be unenforceable. Capacity to be bad definite terms. There are also going to be contracts that or more. That would violate the state's usury laws. Contracts like that are void against public policy. We're going to look at covenants not to compete, restrictive covenants, and exculpatory clauses. A lot of times those are unenforceable. We're going to look at unconscionable contracts, contracts that are so unfair and so biased against one party that they shock the conscience and are also illegal. Capacity. The law presumes that the parties have the mental capacity to contract. However, certain persons lack the capacity to contract. Those would be minors, insane persons, intoxicated persons. At common law, there's also state statutes and codes protecting persons who lack the contractual capacity to form contracts and have contracts enforced against them. If a person lacks capacity, but there's still offer, acceptance, and consideration, that contract is unenforceable and it can be voided, meaning that it's voidable. It's not void, it's voidable. The party asserting the lack of capacity or his or her guardian bears the burden of proof. Let's talk about insanity. Someone who is adjudged insane in a court of law, the contract is absolutely void. Neither party can enforce the contract. However, if someone is insane, but they have not been determined insane in a court of law, for example, someone maybe who has a serious mental problem, like for example, let's say they're paranoid schizophrenic, and a psychiatrist can testify to that they are insane, but a judge has not made that determination, that contract would be voidable. It could be disaffirmed by the insane person or their representative. However, if they enter into a contract for the purchase of a boat, the seller of the boat, if that person is mentally sane, they cannot avoid the contract. It is only the person who lacks the capacity who can disaffirm and avoid the contract. So it's good to know. If a person's adjudged insane, contract's void. If the person is a minor, or if it's someone who is insane, but that has not, a judicial determination hasn't been made, the person lacking capacity can avoid the contract. The person who is rational cannot avoid the contract. Let's talk about intoxication as defense. Most states provide that contracts entered into by intoxicated persons are voidable by the person. The intoxication may occur because of alcohol or drugs. The contract is not voidable by the other party if that party had contractual capacity. So if you think about your friends or coworkers going to happy hour, somebody drinks too much alcohol or beer, and then they say, I'll sell you my house for $100. Can you enforce that contract? Well, the person who is intoxicated can avoid and void that contract. They can disaffirm it because they lacked the capacity to contract. No one would take them seriously if they are intoxicated at a happy hour saying, I'll sell you my house for $100 because I'm so sick of it. No. In that instance, intoxication would be a defense to enforcing the contract. Let's talk about legality. One requirement to have an enforceable contract is that the object of the contract must be lawful. Most contracts that individuals and businesses enter into are actually lawful. They're enforceable. These include contracts for the sale of goods, services, real property, intangible rights, the lease of goods, property, leases, licenses, and other contracts. Some contracts have illegal objects. For example, here in Nevada, gambling is legal. It's also legal in New Jersey. It's legal in Colorado. It's legal in New Mexico. Gambling is legal in California. Gambling, however, is legal in Oklahoma. Let's suppose that gambling is illegal in Wyoming. Okay, so if you have a contract to sell or purchase slot machines or to open up a casino, that contract would be void because it's illegal. So if you have a contract for an illegal purpose, a contract for the sale or purchase of marijuana, for example, in Maryland, where it is not legal, that contract has an illegal object. A contract for hire. People get sick of their spouses all the time and they think, I'll just kill this person and get the insurance money. If you've ever watched any criminal reenactment television shows, you know that's a bad idea because they always get caught, right? But people still do that. They try to hire someone to kill their spouse thinking that they're going to get the insurance money. A contract for hire, solicitation for murder. If I agree to pay someone $10,000 to kill my spouse and the person kills my spouse, but I don't give them the $10,000, I keep all the insurance money for myself, they can't go into court and enforce that because that contract has an illegal subject matter. So a contract that has an illegal object, sale of alcohol during a period of prohibition, for example, sale of alcohol to a minor, an agreement to sell alcohol to a minor. Purchasing alcohol is illegal for minors. So anytime the subject matter of the contract is illegal, that contract is absolutely void. It has no legal effect. Let me know if you have any questions about illegality. Illegal bargain is a contract to perform activities that are prohibited by law. Usury is an example. Again, a contract to enter into a loan with an excessive interest rate, one that exceeds what's allowed according to the state statute. There's a state statute. The state statutes are there in part to protect consumers. So if consumers are going to be subject to, again, payday loans with these extremely high interest rates, that's usurious. That violates the usury laws against charging excessively high interest. That's a very oppressive agreement, and it's illegal. It's an illegal bargain. Cannot be enforced. It has no legal effect. An illegal contract cannot be enforced by either party because it has no legal effect. If you were to go before Judge Judy and try to enforce a contract that's usurious or to enforce an agreement to commit a crime like the distribution of drugs, even in states that allow the use of medical marijuana or allow the personal use of recreational drugs, it's still often illegal for individuals to sell, deliver, and distribute those drugs. So an agreement to distribute drugs, purchase drugs from an individual, that's still illegal in most states. So that would be an illegal bargain. You cannot go before Judge Judy to enforce a contract to purchase drugs, okay? It's not going to work. It's an illegal bargain. Let's talk about special business contracts and licensing statutes. Contracts that unreasonably restrain trade are held to be unlawful. Price fixing and non-competition agreements. Sometimes companies will get together, companies who are competitors in a particular industry. For example, paint stores might get together and say, hey, let's just charge $20 for a can of paint. We'll all agree to charge $20. That way the consumer can't run to another store and get a lower price. They have to pay $20 for a bucket of paint from us. Companies get together and do that. That's price fixing. It violates free market principles. It's illegal. So a contract like that for price fixing is illegal. Non-competition agreements. Sometimes professionals go to work for a company. For example, if a doctor joins a medical practice and starts to work for a particular with a medical group, they may have to sign a non-competition agreement saying that they will not leave that medical group, take all the clients, and start a competing company right across the street. That's a non-competition agreement. If that is an unreasonable restriction on, for example, the doctor's ability to practice medicine, that agreement might be void against public policy. Certain contracts, non-competition agreements for professionals, in certain cases, they may be disfavored by the law, seen as illegal. Now, all states have licensing statutes that require members of certain professions and occupations to be licensed by the state. Can you think of an example? I think of a real estate agent. Most real estate agents have to be licensed. Brokers have to be licensed. Contractors, architects, some of them have to be licensed. So if a general contractor gets a contract, for example, to develop a mall, and the owner of the property fails to pay the general contractor after the mall has been built. The general contractor goes into court and says, well, I'm suing. The court says, well, where is your license? If that contractor is unlicensed, for example, in Texas, they may not be able to get paid for their work. So under certain circumstances, a business license is required if you intend to get paid for the work that you provide, your personal services. Licensing statutes are enacted to protect the public. They're regulatory statutes. Again, unlicensed persons generally cannot recover payment for services that a regulatory statute requires a licensed person to provide. Let's talk about unconscionable contracts, contracts that are unfair. So the Constitution says that no state shall impair the obligation of contracts. So the right to contract is fundamental in America. It's in the Constitution. No state shall impair the obligation of contract. So there is a freedom of contract, though, as long as the object of the contract is lawful and the elements for the formation of the contract are met, the court will enforce private parties' agreements according to their terms. However, sometimes a lawful contract is so oppressive or manifestly unfair that it is unjust. To prevent the enforcement of such contracts, courts have developed the doctrine of unconscionability, which is based on public policy. Have you ever entered into an agreement with a tiny little printed form that you're supposed to sign? Or you purchase a computer on the internet and there's some clickable terms at the very end. You have to click and agree to these terms. You don't read that, but you just click on it. If you're waiving your right to bring a lawsuit, agreeing to arbitration, and the print is so small that you can't see it, that arbitration agreement will not be upheld in court. I recently read a case where a blind customer purchased something in an electronic store, and she did not see what she was clicking on at the point of purchase. She used her credit card, swiped it, but there was a button where she clicked where she was waiving her right to bring a lawsuit. And the court said that's unconscionable to hold a blind person responsible for waiving their right to bring a lawsuit when they couldn't see the terms they were agreeing to at the point of purchase. So that would be unconscionable. Waiver of liability, other disclaimers that take advantage of consumers. Certain states definitely have more liberal laws that will protect consumers more. And in those states, anything that takes advantage of a consumer may be deemed unconscionable and therefore unenforceable. Let's talk about unconscionability. The following elements must be shown to prove that a contract or clause is unconscionable. The parties possess severely unequal bargaining power. A lot of times merchants have much more power than consumers. Merchants have the ability to control the terms of the purchase, the terms that are on their receipts and their forms. The merchant is in control of all that. All you do is purchase something and sign away your rights. The parties possess severely unequal bargaining power. The dominant party unreasonably uses its unequal bargaining power to obtain oppressive or manifestly unfair contract terms, and the adhering party has no reasonable alternative. They're sometimes even called contracts of adhesion. But an agreement like that is unconscionable may be deemed void. Let's move on to electronic contracts, which since the pandemic, so much more business is being done online. And that really benefits Jeff Bezos greatly. He had a vision in the late 90s when he was sitting at home with a desktop computer, is sitting in his garage thinking about starting a company called Amazon. He's truly a self-made billionaire, Jeff Bezos. He had a vision of e-commerce in the late 90s. So the use of the internet and the World Wide Web and the sale of goods and services through e-commerce has exploded. Contracts can also be created via email. Electronic contracts or electronically made agreements, they are just as enforceable in court as an oral agreement or a written agreement. You don't even need an electronic signature because you can create contracts via email. One of the challenges, though, is determining what the actual terms of the contract are. Let's talk about e-contracts for consumers. Again, the consumer may not actually even know the seller, since many purchases online from small businesses are made by contracting businesses, such as on Amazon. For example, I used to be a seller on Amazon maybe 10 years ago. I had a store called Kathy's Corner. I would buy items for a very low price and I would resell them on Amazon at retail. And I made quite a bit of money doing that. It was really just a hobby. Um, but if you were to purchase something on Amazon, you would think you're buying it from Amazon, not really knowing that it's coming from Kathy's Corner. Okay. So sometimes you don't even know who the actual seller is. But of course, rest assured, if something broke during shipment, the customer finds out pretty quickly, who Kathy's Corner is, and when I get ready to issue a refund for something that say breaks. Same thing. I purchased things during the pandemic. I purchased more things online at Walmart. One thing I purchased was an air purifier. I felt, I needed to, purify the air for many reasons, including air purifiers can actually, reduce the amount of COVID that is in the air. So I purchased a couple of air purifiers online at Walmart. I didn't realize that one of the air purifiers I bought was not being sold by Walmart, but it was being sold by a private seller. So when I got that air purifier, I wanted to return it, but I couldn't easily return it because even though I purchased it through Walmart.com, it was listed by someone private. So I ended up keeping that air purifier, and if I had wanted to return one of the air purifiers that Walmart itself had actually sold, it would have been easier. So, again, in that instance, I thought I was buying something from Walmart, but I wasn't. So when you purchase something on a website, understand anybody can list on Amazon, anybody can list on eBay, anybody can list on Walmart. When you purchase something on eBay, you are not buying it from eBay. You might be buying it from a private individual like myself who, once had a storefront on eBay. I was a highly rated seller on eBay. I never had any complaints. I had a 100% rating, when I did business on eBay. But you don't really know that you're buying it from me. You probably think you're buying it from eBay, but you're really not. So if you don't know who you're buying from as a consumer, it makes it even harder to understand the terms of the agreement if you don't know who you're buying for. So these are some of the challenges with consumer e-contracts. Warranties. There's usually a promise when you purchase a product that it will be fit for its ordinary use and it will be repaired if it is not. Sometimes a product comes with an express warranty, and that just means the label of the product should say what it is. The product should be what the seller says it is. Express warranties may be stated to you when you purchase a car. They may be told to you in a store that this product is great in it. This car is going to last you for 5 years without breaking down, and it goes from 0 to 60 in 5 seconds. In addition to those express warranties that are stated or written, there are implied warranties that are implied at common law. One is the implied warranty of fitness for ordinary use, and that is the ordinary warranty, which makes sense when you purchase a product. Does it do what it is expected to do? If I purchase a bed, I expect to be able to sleep on that bed without it crashing. If I purchase a mattress, I expect that product to be, fit for its ordinary use. The implied warranty of merchantability means that a seller guarantees that the product does what a product of its sort normally does. If it does not, you can bring a lawsuit for a breach of the implied warranty of fitness for ordinary use. That's also called the implied warranty of merchantability. Those are the same thing. A different type of warranty is the implied warranty of fitness for a specific purpose. If the seller has reasons to know and understand the purpose that the buyer is buying the product for, when the seller and buyer are both businesses and there's a contract that specifies the purpose. So again, if the seller knows what the buyer needs the product for, then there's an implied warranty that it will be fit for that specific purpose. And if it doesn't work, the buyer can sue for breach of implied warranty of fitness for a specific person. Now, a lot of times businesses will try to get out of their warranties. They customarily try to limit warranties. It's a myth that businesses add warranties. They're always trying to do what is in favor of the business, not the consumer. That's why the law steps in and creates these special protections. Warranties are established by state law. The standard when set by law can be excluded or limited unless that's prohibited by consumer protection laws. A business may totally exclude the warranty of merchantability. This limits the lawsuit risk. Under UCC 2-312, there's an exclusion of merchantability that says, look, if a business wants to exclude merchantability, which is a warranty that it's fit for ordinary purposes, it must be in bold, in caps, and with large typeface. That's New Jersey Statute 12A-2-316. That's the New Jersey provision of UCC 2-316. So in New Jersey, if you want to exclude a warranty, it better be in large, bold print so that the consumer can see it. Otherwise, it's not going to be considered a valid way to get out of warranties. So in your Module 5 learning materials in Blackboard, there is a knowledge check on warranties. You want to make sure that you do that so that you'll be ready for the Module 6 quiz. Let's talk about your written assignment for Module 5, cheating the elderly. In our scenario, Johan and Mary are helping their grandfather who has dementia. They want to receive Jacob's assets, but they're aware that they may be accused of elder abuse by cousins or other family members. So they've asked your supervising attorney to prepare a contract for Jacob to sign. They will do normal weekly housekeeping and look in on Jacob at least 3 times a week. However, they want the remaining funds payable over a 3-year period. They will not do any personal care, but arrange for his care as needed. They want a salary from their grandfather's Social Security and his 401k earnings, and they want a lump sum of $50,000 at the end of each year. Does that sound fair to you? Or does that sound like Johan and Mary are cheating the elderly? Should Jacob outlive his assets, they plan for him to go on Medicaid and assisted living at state expense. This is the agreement. So the issues in this case are both ethical and legal. Ethical challenges include, what is the role of the attorney? And should Jacob have his own attorney? Should an attorney allow Jacob to enter into an agreement like this? Does he have the mental capacity to contract with Johan and Mary? So, answer these questions in order, please, as you write your written assignment for Module 5. Find the very latest case in Lexis Advance and Fast Case from any state using a search like voidable contracts and incapacity. Put the term voidable contract in quotations. That way the case search will search for the terms voidable contract together. When you're searching for a term on Lexis Advance, you need to make sure it is in quotes. Okay, find and cite the case that is most recent on contract law and undue influence. Make sure you're looking at contract cases, not criminal law cases. So you would use this term, search, undue influence, the ampersand, contract, and then in caps, not crim, and put the little asterisk there. That means that when you search on Lexis Advance, it will ignore criminal cases. We're dealing with a civil matter, which is contract law. Criminal law deals with actions brought against the state, against a criminal defendant to put someone in jail. We're not dealing with that in this course. We're dealing with civil law for money damages. So we want to be looking at civil cases pertaining to avoidable contracts and incapacity. 3, take a position on the legal and ethical issues presented in the scenario. Support it with your sources. Now, you will need to do 2 IRACs. 1, the first issue, is fraud or capacity involved? What's the rule? State the rule on fraud or incapacity, which says that if a person who lacks mental capacity to contract entered into an agreement, they can disaffirm it. Analyze the scenario involving Jacob, Johann, and Mary to see whether or not the grandfather can disaffirm this agreement, or if he has the capacity to contract at all with dementia. So that's what you'll be IRACing. The second issue that you'll be IRACing in the same essay, if the attorney agrees to do the contract and no separate counsel reviews it for Jacob, is this a violation under the ABA code or the model rules? So you'll need to look up the issue. An attorney agreeing to create a contract for someone who lacks the mental capacity and lacks their own attorney. Cite to the relevant rule, and then analyze the scenario and reach a conclusion as to whether or not it is ethical for the attorney to write this contract without having anybody review it for Jacob. And again, when you're a paralegal or an attorney working in a law firm, you always want to analyze what the other side might argue. So if you're going to argue that Jacob lacks the capacity to contract, you need to consider how the other party would argue that Jacob has the capacity to contract because he's never been adjudicated insane or lacking in capacity. So just think about the arguments that the other party may say in response to what you argue and put that at the conclusion. So simply follow steps 1 through 7, double space, follow Blue Book form, write this up as a memo with a title page and caption, and submit that assignment by Sunday at midnight Central Standard Time. End of term reminders. Your written assignment for Module 5 is due Sunday, May 8th. There is a live session question for this week. Question is, what is the implied warranty of merchantability? Be sure to define that and submit that answer into the live session answer box. Next week will be a short week. Your live session will be pre-recorded. I will post that video recording on Sunday because it includes a quiz review. So you will need to have all of your assignments for Module 6 due on Tuesday because spring term 1 ends Tuesday. No assignments can be accepted for grade after the term ends. If you have any questions or concerns, feel free to reach out to me. Send me an email. My e-door is always open to you, and I hope everyone has a terrific week. Thanks for watching.